Chapter 3, Providing Equal Employment Opportunity and Safe Workspace. Learning objectives. Explain how the three branches of government regulate human resource management. Summarize the major federal laws requiring equal employment opportunity. Identify the federal agencies that enforce equal employment opportunity. Describe each role. Describe ways employers can avoid illegal discrimination and provide reasonable accommodation. Define sexual harassment and tell how employers can eliminate or minimize it. Explain employers' duties under the Occupational Safety and Health Act. Describe the role of Occupational Safety and Health Administration. Discuss ways employers promote safety, worker safety, and health. So when we look at regulation of human resource management, we look at the three branches of government. Excuse me. So we have three branches. We have the legislative, executive, judicial. Of course, you know, your legislation, that's your Congress, the people that pass laws. Executive, that's the president and the executive and the cabinet members and stuff. Judicial is the court system. So the forefathers set this up in our country so that we could never have a king and somebody could never have all the power. So it's divided up among these three branches. Equal employment opportunity. So you look at equal employment opportunity, condition in which all individuals have an equal chance for employment. Government regulates human resource management to ensure EEO. So from here on, I'll be referring to as EEO, equal employment opportunity. You have constitution amendments, legislative, executive orders, and court decisions. So when you look at all these things that brings into place and stuff, you see where you have constitutional amendments. This is Congress right here. The legislative is stuff where it comes through there. Also, executive orders is through the office of the president and his cabinet members. And court decisions, that's the judicial system. Now, when we look at the constitutional amendments, we're going to look at a couple of them here. 13th Amendment is most notably known for abolishing slavery in the United States. It has been applied in cases where discrimination involves symbols and incidents of slavery. Now, even, you know, slavery was abolished many years ago, we still had incidents in this country where slavery does pop up. And a lot of times when we see where individuals, particularly when people have immigrated to this country and someone brought them in through illegal means and got them working in illegal capacities and things along those lines. 14th Amendment, it forbids states from taking life, liberty, or property without due process. Basically, you can't have the states come in and just say, you know what, we don't like you, Jim Johnson, so we're going to take your stuff. You have to go through due process. What is the basis? What is the legal basis for you to take something from Jim Johnson? Prevent states from denying equal protection of discrimination. It also basically says, you know, everybody has a right, the same rights. So we can't give some people rights and take away other people's rights. It applies to decisions or actions of government or private groups whose activities are deemed government actions. So this is how it covers a lot of folks under that when you look at the different umbrella, the different types of groups that fall up under there. Legislation. So when we look at legislation, the Civil Rights Acts of 1866 and 1871. So when we think in terms of, you know, we look at this, you know, we think of so this is going back like during Reconstruction. So Congress passed two Civil Rights Acts to further, you know, the 13th Amendment. And the goal was abolishing slavery. You know, the Civil Rights Act, the 1866 granted all persons the same property rights as, you know, as everybody else. So it wouldn't be just one group of people can have and others could not have. Equal pay. And this is really comes into play too, is where is established the Equal Pay Act, whereas, you know, not only when you look at segregation and slavery and things along those lines, you had situations where people wanted to pay. Let's say that you had a white man and a black man and a brown man that was doing the same job. Well, prior to this act, the white man would definitely be making more. And what the black man was making, what the brown man would be making, would be nowhere near what the white man was making, even though they did the same job. So this is why it was put into place. And also it comes into play women. When women particularly came into the job market and stuff, now it wasn't a racial thing, it was a gender thing. And they were not being paid equal just because they were women doing the same job. So this is the Equal Pay Act that was passed to protect all individuals from that. And so when we look at the enforcement of the Civil Rights Acts, the title of the Civil Rights Act of 1964, enforced by Equal Employment Opportunity Commission. So the EEOC, this is the agency that enforces these laws. And when we just mentioned the equal pay and the civil rights and stuff, and they would investigate. Also, if they found out that there was significant stuff, they can do, they can levy fines and eventually prosecute individuals. Now, you have Age Discrimination and Employment Act, which is the ADEA. This is something that came up now. One of the reasons why this is really important, because people are working longer, they're living longer, and they're working longer. So what you don't want is have organizations say, you know what, even though this guy is really good, and I'm not gonna hire him because of his age. So when we look at age discrimination complaints between 2008 and 2021, one of the reasons these things have gone down is because now employers are well aware that this is something that you can no longer do. And as a result, everybody's aware of it. But not only that, the public is aware of it too. So if you have somebody who feels like they have been age discrimination against, they're looking for it realistically. So now people are practicing, having more fair practices when it comes to hiring, and age discrimination is one of the things it's on a decline. So legislation, Vocational Rehabilitation Act of 1973. So organizations must engage in affirmative action for individuals with disabilities. So when you have individuals who have disabilities and stuff, you can't discriminate against them if, you must have opportunities for them to get employment and also make accommodations for them, particularly if they can do the job. For instance, if somebody can do the job, but they can't stand for 8 hours, you may have a situation where you might have to bring them a seat so they can actually do it, or they can't access the building. That's really big if they have wheelchairs or walkers and things along those lines. Vietnam Veterans Readjustment Act of 1974. So when you look at the Vietnam veterans' rights, this is a law that was passed that required federal contractors and subcontractors to take affirmative action towards hiring veterans from the war when they came back. Remember, a lot of these guys had gone in the war. They had been gone for several years. So the government came through and passed this act basically saying if you're a government contractor, then you must give them opportunities for employment. Pregnancy Discrimination Act of 1978. Obviously, going back prior to that, if women got pregnant, some of them lost their jobs. Some of them would not get promoted because of this. And this was an act that was passed to protect women who were pregnant, because they were discriminated. And realistically, it hit all segments of life, to include Hollywood. There's one famous lawsuit that was settled, I think probably in the 1990s, where an actress was pregnant. She got fired, and she was working on a TV series, and she was a beautiful lady and had a sensual role. Well, management determined that basically when she got pregnant, she was no longer be beautiful and meet the male standard of beauty, and she couldn't be pregnant, so they fired her. She sued and successfully won, and I remember that case very vividly. Americans with Disability Act. So you got the ADA. So this protects individuals with disabilities from being discriminated against in the workplace. And it clearly defines the word disability. You have some people that prior to this act, they were struggling to get jobs and stuff because they were discriminated against because they had a disability. Keep in mind, it didn't mean that they couldn't do the job. It was because they weren't like everybody else. So some people discriminated against them in hiring processes. Disability associated with complaints under the ADA for 2021. So let's look at this. So when we look at the pie chart, we see one of the things, disability associated with complaints. So we see the complaints, mostly the largest portion is emotional and psychiatric. So you see that's 33%. The next largest group you see is going to be just others in general. But when you look at specific group, you see right here, regarded as disabled. And so now you see the other versions of where people had disabilities associated with complaints filed under ADA. And there are times when you have some managers who are not necessarily aware of all the laws, and they make some decisions that are adverse, and that's when people file complaints, and rightfully so. Legislation, Civil Rights Act of 1991. So when we look at the Civil Rights Act of 1991, so this broadened basically, the Civil Rights Act of the previous Civil Rights Acts. And one major change under the law with 1991 was addition of like compensatory and punitive damage in cases, involving discrimination from the ADA. So now you could be sued and you have to pay. And this is how you get some large organizations to comply. They don't like paying out money. And so that's why it was amended to add that in there. Uniform Services Employment and Reemployment Rights Act of 1994. So, this is where employers must reemploy workers who left their jobs to fulfill military duty. So if someone left their job to go fulfill a military duty because they're in the reserve or the National Guard, well, when they come back, they're supposed to have their job. If you come back and say, well, if they come back and say, well, we gave your job away, this is the act that protects them from that. Genetic Information Non-Discrimination Act of 2008. So when we look at this one, it prohibits actions, by employers, specifically when they're using like genetic information and making decisions about what they do, to include persons' genetic tests, testing of that person, of family members, medical information, things along those lines, where somebody could get a hold to that and make a decision based upon that. Lilly Ledbetter Fair Pay Act of 2009. It covers discrimination in pay, that is, not being paid the same as one of the co-workers where the difference is due to race, color, religion, sex, tradition, or disability. So you see, even up until 2009, we're still adding amendments to cover this. So when we look at this right here, I won't read all the way through this, but what it does, well, actually I will. You have Eric Miller, an Army Reservist sergeant who was deployed for service with the 363rd Military Police Unit in Iraq for over a year. When he returned to the States, he was able to resume his job as an elementary school teacher thanks to the Uniform Services Employment Rights Act. This act requires employers to reemploy service members in the job that they would have had they not left. And see, this is why this is important. Because let's just say that this person was in a position and that position got promoted. People in that position got promoted. Well, when this person comes back, they're supposed to get promoted too. You can't say, well, you were gone for a year, so I'm promoting everybody else, but not you. So all the things that they would have had or would have been entitled to, you have to make sure they get. So executive orders. So, look at these executive orders, prohibits federal contractors and subcontractors from discriminating on race, color, religion, sex, or national origin. This is big. So when you look at federal contractors, some of these contracts are multi-million-dollar contracts, and some of these contractors are multi-million-dollar businesses, and they have a lot of people that they employ. So if they're discriminating, that could be pretty significant. So this is why that's prohibited. As big as the federal government is, the secondary to the federal government is all the contract work that people are doing for the government. Employers who contracts meet minimum size requirements must engage in affirmative action. So if you have an organization that is a certain size, the government says that, let's say, and I think it said, let me see if I can, you must be doing at least $10,000 worth of business with the federal government for this to be applied. Then you have to make sure that you're being fair in your hiring practices. When there's violations of this, these are enforced by the Office of Federal Contract Compliance. So Executive Order 11478 requires federal government to base all employment decisions on merit and fitness. So when you're looking at this requires people to, basically give people a fair shot. But what you can't take in consideration is, well, I'm not promoting him because he's Arab or he's Indian or black or white or whatever it may be. Also covers contractors doing at least $10,000 worth of business with federal government. Enforced by the U.S. Office of Personnel Management. OPM is what it's commonly referred to. So the government's role in providing for EEO. So So you have the EEO Commission, which also monitors, organizations' hiring practices and reports the number of women and minorities employed in different jobs. They keep up with that stuff. They collect data. And sometimes you can have a situation where you're looking at data and you can see some things. Well, obviously something must not be right here, because you see that they may not be hiring various women. Let's just say you look at this organization, you see they haven't hired any women. They don't have any women that work there and haven't hired any, and in no job. Wouldn't that be odd? Yeah. And this is why they will be looking into that. Issues guidelines to determine law violations, uniform guidance on employee section procedures. So not only they get these reports, they analyze this data and they provide this data to folks. And this is the basis for whether or not, something is something that can be settled with just a conference or a letter or a phone call or litigation. Types of charges filed with the EEOC. So you look at retaliation. And if you look at, see which one's the biggest, the largest retaliation. Now, what retaliation means is this. Let's say that you work for me and I'm your manager and I tell you to do something wrong, or we're not doing something that we're supposed to do. And then you bring it to me and I tell you, no, we're going to keep doing it. And so now you report it to my manager. And then I suspend you for something I make up. That's retaliation. And you can see that's the largest group. So in essence, people are people. And a lot of times I can tell you emotions get involved in things. And as a result, it's like people will have a mentality, I'm going to get back at this person. That's retaliation. And you see the next largest group right there is actually disability. So people who have disabilities. And this is one of the reasons why a lot of people don't like to tell what their disabilities are to folks, for fear of these types of things. So the Office of Federal Contract Compliance Programs. So it enforces executive orders that cover companies doing business with the federal government, audits government contractors to ensure they are actively pursuing goals and affirmative action plans. Affirmative action plans must include utilization analysis, goal and timetables, and action steps. So they're going to go through this and they're going to monitor stuff with a fine-tooth comb. Again, when you have as many contractors, and you all will be shocked to know how many contractors there are with the federal government. There are a voluminous amount. And as a result, the more you have, the bigger they are, the more opportunities you have for things to go wrong. And somebody's got to monitor that. And these are some of the things that, when they look at these organizations, these are some of the steps they have to go through. Avoiding discrimination and disparate treatment. So this is this is very busy, EEO. So this is very significant because this goes way back from in the past to present day. So you can't have disparate treatment. And this is basically treating somebody different because of their race, creed, color, religion, sex, or culture. Companies should evaluate interview questions and decision criteria to make sure that the job related and applied equally. So in essence, you can't have interview questions that are designed to be advantageous to men. And if you do, that's disparate treatment of women, of females. And so if you do, that's where that's going to be a problem. Certain factors legal when there is bona fide occupational qualification. So now you can have stuff that says, well, I'm having the questions this way because the job requires people to have these fundamentals. Well, see, that's legal right there. I mean, obviously, let's say if it's a job that requires you to lift 50 pounds. Well, there are a lot of women that can't lift 50 pounds in general population. So that wouldn't be a legal issue right there. It's the fact that, I'm hiring people who can lift 50 pounds or more. Unnecessary but not merely preferred qualification performing the job. Supreme Court rule, BFOQ are limited to policies directly related to workers' ability to do the job. So when you're talking about, these questions and these tests and stuff is directly related to doing the job, and it's not based on anything else. That's what keeps it legal. Disparate impact. So this is a condition in which employment practices are seemingly neutral, yet disproportionately exclude a protected group from employment opportunities. Often it's unintended by the employer. So when you have something like this, this is where you can, I'll give you an example. A disparate impact could be the fact that, you don't have anybody, you have a large organization, but you don't have anybody that works with you who is a member of the Army Reserve or the Army National Guard or Reserve or National Guard. And it's not that it was intentional, but as a result, it's a disparate impact on this group of people. 4/5 rules, commonly used to test a disparate impact in hiring practices. If hiring rate for a minority group is less than 4/5 the hiring rate for the majority group, there is evidence of potential discrimination. So you see that they even have a mathematical equation. And we're going to take a look at that. So here's an example applying the 4/5 rules. A new hotel has to hire employees to fill 100 positions. Out of 300 total applicants, 200 are black and the remaining 100 are white. The hotel hires 40 of the black applicants and 60 of the white applicants. So, you go through and you work the math and you see right here how you work it. And then you compare the rates. See, the 4/5 requirement is not satisfied, providing evidence of potential discrimination. So when you see that, it's like, okay, well, that's not right. The 4/5 rule right there. So they were disproportionate. Less white applicants, but more white applicants. Less white applicants in the process, but more white people got hired. Businesses' role in providing for equal employment opportunity. Avoiding discrimination. Employers can establish and enforce an EEO policy, defines and prohibits unlawful behaviors, provides procedures for making and investing complaints. So when you're looking at this, just a couple of things they do is try to educate your folks about this. Put flyers up in conspicuous areas, have workshops, have annual training about this, and provide procedures for making and investigating. You got to have a process that you go through to investigate. It has to be something that makes sense, and it's systemic. It's something that you always do in those situations. Affirmative action and reverse discrimination. Some argue that affirmative action is reverse discrimination. Fewer white males can be hired due to preference for women and minorities in hiring. So you will see here instances where some people will claim reverse discrimination. If you hear it, it's usually primarily referring to white males when you normally hear that. And listen to this. In reality, you can have some situations where that does happen. And it can be mathematically proven that somebody or somebody's is actually discriminating against white males. And if that's the case, then, that's something that, will be investigated by the EEOC, and that would have to be remedied in some capacity. Recruitment. Military veterans continue to be a sought after group of motivated workers in today's workforce. Why? A lot of times it's because of the training that they get. See, if you can hire somebody who's a military veteran who has some extensive training and specialized training, and you didn't have to pay for it, and you didn't have to send them to get it, this is why they are coveted, because of the skills, because they had a career where the government, the military, paid for them to get all this stuff. Now they may be retiring or getting out of the military, and this is something now you can use all that money that was spent to train and educate them. Now you can get their expertise and bring it to work at your place of business. So polling question. So which statement is false? During an interview, it is legal to ask only women if they have childcare needs. Hiring only men to model male underwear is legal. If a company unintentionally hires a disproportionate number of non-minorities, they can be held liable for discrimination. Organizations can screen candidates using a test that reliably predicts on-the-job performance. So what do you think the answer is? Your answer is A. During an interview, it is illegal to ask only women if they have childcare needs. And let me tell you, that is something that even happens to this day. Providing reasonable accommodation. So when you talk about providing reasonable accommodation, this takes a lot of things in consideration. Employer required to do something to enable all otherwise qualified applicants to perform a job. religion, and disability should be considered. Employer may exempt from providing accommodation if it would require significant expense or difficulty. Accommodation reasonable if it does not impose undue hardship on employer. Employers may perceive more hardship than actually exists. So when you have to look at reasonable accommodations, and when you as an employer. And I'll give you an example. What if you have 10 people working a job, and as a result they've been on this job, but now you're actually going to have them doing something different, and let's say that they're manufacturing something, but now for them to do that, you're going to change some of the things around in their working environment. And when you did that, you changed the height of something that was that they had to reach. Well, you actually have a guy who's 5'3" working there, and he can't reach it. So a reasonable accommodation would be is to provide him a step stool or something that he can stand on so that he can reach to do that. That is. Now, if it's something that requires someone to operate at that level and move around and do all the other things, a step stool won't work. Now you potentially talking about, I got to spend a lot of money to try to build a whole this and that stuff so he can actually do this. Then that's when the employer say, okay, this is undue expenses on us, and this is not reasonable. Reasonable accommodations do not include hiring unqualified person, lowering quality standards, or compromising coworker safety. So understand that none of that applies. Sometimes there are some applicants who believe that it does, but it does not. Businesses' role in providing for equal employment opportunity. So preventing sexual harassment. Unwelcome advances, requests for sexual favors, and other verbal physical contact is sexual harassment. When submission to conduct is a condition of employment, submission/rejection is the basis for employment decisions. Conduct interferes with employees' work performance. Different kinds of sexual harassment. Quid pro quo, hostile work environment. So when you look at the sexual harassment, that's why this is there. Goes back since as long as we've had people in the workplace, and it still goes on today, unfortunately. And I can tell you, I have very good friends of mine, female friends of mine, who I've worked with, coworkers, and some of the stories that they've told me, in later years, that some of the things they had to go through was just mind-boggling. And when you look at these things, and quid pro quo, that basically means you do something for me, then I'll do something for you, and that's illegal. And then you have a hostile work environment where basically, I didn't fire you, but I made your life such a living hell that you left. So I ran you off by treating you bad. Preventing sexual harassment. Organizations can prevent sexual harassment by developing and communicating a policy that makes it clear sexual harassment will not be tolerated, training employees to recognize and avoid this behavior, providing a means for employees to complain about harassment and be protected, acting promptly to discipline those involved. All of the above right there. When this happens, it has to be what employers do. They post signs. They have annual training that employees must go through. They want everybody to recognize the signs of it. They want everybody to be aware of it. They want people to report it. And what they must do is swiftly take action once it's been reported. Now, remember, when I say take action, that is to investigate, because you may find that it's true or invalid, or you may find it is not true or invalid, but you have to look into it quickly. And when you do, or you can substantiate and prove that somebody did do it, you have to act accordingly, and there must be some type of discipline administered. One of the reasons why is you need to send a message to other folks who might have a tendency to want to do that, not to do it. Most people won't do this because it's the right thing to do. Some people won't do it because they're scared they're going to get caught. So, polling question, have you ever experienced sexual harassment in the workplace? And I'm going to say, if the majority of folks listening to this, there's going to be a higher probability for females than there will be males to say yes. Valuing diversity. So some view diverse workplace as a competitive advantage. Having diversity in leadership is important. Organizations may practice affirmative action, including LGBTQ plus community. So when you're looking at bringing people in, and realistically, when I've heard in my career, when people talk about not hiring diverse people, they don't give valid reasons why. And one of the reasons I tell folks, if you're looking for the skill sets, the education, the language, the culture, age, all these other things, you take into consideration and hire good people. As a leader, as a former senior non-commissioned officer in the United States Army, one thing I never concerned myself with was what somebody's sexuality was and who they slept with and who they had a partner with. My only concern was, could they do the job? And if people did that, a lot of this right here wouldn't matter. Unfortunately, sometimes people can't do that because of personal beliefs or issues or their culture or where they come from. So they struggle with that. But there can be legal consequences of that, of you not doing these things. Occupational Safety and Health Act. So passed in 1970 in response to roughly 15,000 work-related fatalities that had been occurring every year. Authorizes government to establish and enforce occupational safety and health. Occupational safety and health inspects companies for safety and health standards, levies fines for violations of standards. So this is why organizations, businesses try to be on the right side of the law that was passed in 1970, because it can come with some serious consequences. Prior to that, there was a lot of people getting killed because there was basically, when they investigated and looked in the workplace, it was unsafe. People were doing things that just didn't make good sense. Because realistically, people's health and safety and welfare was not at the forefront, profit was. So therefore, we're just going to do what we need to do. And if somebody dies on the job, I'll just replace them. That was the attitude. Now, that comes with consequences. And when incidents do happen, they are investigated by OSHA. And OSHA will come in and they will make a determination, as to how this happened, what happened. Was there negligence or was it a fluke accident? General and specific duties. So you have a general duty clause. Employers must furnish each employee a place of employment free from hazards that can cause or likely to cause death or serious physical harm. Employers must keep records of work-related injuries and illnesses and post an annual summary of them. So when these things happen, they're documented. Now, organization can get in serious trouble if they're not documenting this stuff. One of the reasons why somebody would not document this is because they're trying to hide something. So that shows some type of, I'm going to say that's not negligent. It's almost like a criminal intent. It's malicious. If not criminal, it's at least malicious. So this is what the form looks like. You can pause and read through that. So general specific duties. Employees have the right to request an inspection, have a representative present at an inspection, have dangerous substances identified, be promptly informed about exposure to hazards, and be given access to accurate recording regarding exposure, have employer violations posted at the work site. So OSHA requires this. And this is to make sure that, this is to protect the rights of employees. It's to make sure that they are informed and things are done right. And they know and everybody else knows what's been going on. So, organizations can't go through, let's say that organizations had 500 incidents with 75 people dying in the past year. Well, they can't sweep that under the rug. This is the kind of stuff that has to get out. And this is what OSHA will be looking at, and all the employees would know about it. OSHA is responsible for inspecting businesses, applying safety and health standards, and levying fines for violations. OSHA regulations prohibit notifying employers of inspections in advance. So when they do these inspections, they're unannounced. They show up. Why do they do that? They don't want to give somebody time to go and hide things and fix things and cover up. So they just show up out of the blue to do the inspection. And now what they've done is either you caught somebody who's got some problems, or you just surprise somebody who doesn't have any problems and they don't mind you going through. And one of the things, as a former investigator for the federal government, I can tell you is this. A lot of times when people have done things they shouldn't have done, or they're lying about stuff, or they're trying to cover up, there's this malicious or a criminal intent. If you talk to them enough, you'll start picking up signs. Maybe not what they're saying, but they'll act awful nervous, or they'll start saying and doing things. And if you talk to somebody else about the same stuff, their answers may be different. Why would they be different? if everybody's supposed to be knowing the same thing and doing the same thing, because something's wrong. Enforcement of the Occupational Safety and Health Act. So OSHA conducts these inspections. So a compliance officer reviews the records. Officer conducts a walk-around tour of the premises. Officer conducts employee interviews. Remember I said talking to different people? Officer conducts closing conference with the employer, notes of violations. Employers must correct violations identified during inspection and pay fines. So what they do is they walk in, they unannounced, they come in, they look, first thing they do is they look at the records, and usually they're not by themselves. It's usually more than one. So you're looking at records. Now they're going to tour the premises. Take a look at that. They're going to talk to people, conduct employee interviews that management cannot tell them who to pick. They'll pick the people they want to talk to, and they'll take them off to the side and talk to them to find out what's going on. And then when it's all said and done, they will have, usually after a couple of days, they will have a closing conference with the employer and management team to let them know what they found. Now, once they do that, then they tell them, let's say that they found some violations. Now they tell them what the violations are they found. And then they tell them, I'm going to give you a certain amount of time to fix those. And because we found those, you're going to have to pay a fine. So you have employee rights. So file complaints and request OSHA inspections. Receive information about hazardous chemicals they handle in the course of the job. So for instance, you have employee rights. I'll give you an example. Somebody's hired by a company and they're handling some hazardous chemicals, but they weren't told they were hazardous chemicals. They were just told it was just some liquid. And so subsequently, this person starts developing some symptoms and getting ill. Files a complaint and requests OSHA inspection. They find out that this company was cited before for doing the very same thing. And so this is how you can protect people's rights. Employee responsibilities. Follow OSHA safety rules governing employee behavior. Report hazard conditions in the workplace. So one of the things I can tell you is this. OSHA won't come in and try to investigate something and hold a company responsible when an employee didn't follow the rules and something happened. So the company won't be penalized for that, but the employee will be. By the company, there's a high probability because they didn't follow protocol, organizational policy. And you're supposed to report things, hazardous conditions in the workplace to OSHA, to management, which is supposed to go to OSHA. The impact of the OSHA Act of OSHA raised the level of awareness for occupational safety. Combined rate of illness and injuries has decreased. Increased the number of claims of retaliation against employees who reported injuries. Workers more aware of rights and able to file complaints. Employee behavior is not directly related to OSHA, but must be considered. So one of the things when you have people getting aware, they start reporting stuff. This is one of the reasons you see the retaliation rate going up, because now people are reporting more stuff than they used to in the past. So now you have managers or management who are saying, you know what? Well, OSHA would have never known about this if Linda hadn't said something. So first chance we get, we're going to punish Linda. That's the retaliation. And employee behavior is not directly related to OSHA, but must be considered. Again, did the employee do something that was not consistent with company policy and cause an accident or something to go wrong? Rates of occupational injuries and illness. So when we look at the illness and injuries, you see the rates and stuff. You see there's a slight decrease since 2010. And that's things moving in a positive direction. So employer-sponsored safety and health programs, identifying and communicating job hazards. So job hazards analysis technique. Each job is broken down into basic elements, or each of these is rated for its potential harm or injury. Possesses a special challenge for high-tech companies. New technology consists of wearable devices that connect to the internet. So this is something where each job that you have identified and break down a job and hazards analysis. What are the hazards associated with each job, particularly when you're talking about plants and mills and things along those lines where things are being made and or moved around and stuff. You know, you got to look at what's the potential hazards for each one of those jobs. Companies supposed to know that. And this, you know, particularly when you get into the high tech stuff, you know, this gets a little bit more challenging because it may not necessarily be just lifting stuff. Now you're talking about machines, you're talking about computers and you're talking about lasers and things like that. So it gets a little bit more technical, a little bit more difficult. And now what you see is all these organizations require safety equipment. This is something that there were times back in the day when people were injured, and a lot of times when they sustained some type of injury, they were not wearing safety equipment. The company's in the clear on that. It's the employee negligence that caused it. Employers must communicate job hazards and risks to employees effectively. A paper trail can document history of concerns. Communication must fit audience. Safety concerns and training needs vary by age group. So when you're talking about giving this type of stuff, there's got to be paper trail. Okay, we can show you where the last 5 years where we've trained 2 times a year. This particular training about this job because it's so hazardous. And the communication must fit the audience. Are you telling them the things that they need to know to do their hazardous job? Are you telling them about company policy that regulates what management's getting ready to do? Well, that doesn't help them stay safe. If you're constantly telling them about what management is doing and how we're trying to do things or whatever else, yeah, they need to hear that too. But they also must have communication that fits them, what they do. And when you look at the training and stuff, give you example. If you have a group who are, let's say that they're high school graduates up to about age 23, 24, 25, and they're very young. Okay, if you're talking to that group, you would not be talking to that group the same way you're talking to a group that was 40 and over, because they're different. It's certain ways you connect with them, and you'll connect with them in a different way, a different communication style a lot of times too. So employer-sponsored safety and health program. So reinforcing safe practices. Implement a safety incentive program and reward workers for commitment to safety goals. Start with smaller goals and expand to long-term goals. Take action to correct the problems. Target jobs or hazards most likely to cause injury. So in essence, we think in terms of, and I mentioned several times when an employee doesn't do what they're supposed to do, if it causes a problem, then the company has to deal with them. Okay, now let's flip to the other side of the coin. Let's say that the employee is doing everything she's supposed to do, and her team have operated at a high level, and they follow the rules, regulations, and they're extremely doing well. Then start rewarding them for that. Reinforce the positive behavior. When you do find something that's not right, implement a corrective action immediately. Give example. If I notice that you're doing something wrong on Friday morning, I don't wait till next Monday to talk to you about it. I talk to you right then and there. It's what in the military we refer to it as on-the-spot corrections. Those are the ones that stick with people the most. Target jobs or hazards most likely to cause injury. So when you're implementing the safety incentive program, put it in the places where this is where I really need people to pay attention to what they do. So have some type of an enticement reward system for those folks who are doing these high hazard jobs and doing it without incident. So promoting safety internationally. So a lot of these groups and organizations, they are international. So this is something that you must do international. They're in multiple continents, multiple countries. Employers must ensure safety of workers regardless of which nation they operate in. You can't say, well, I'm only going to take care of the people who are actually in the continental U.S. and I'm not going to take care of people who are at our plant in Canada. Cultural differences may make this difficult. When you have people who have cultural differences, sometimes there are some things that you can butt heads with about, and I give you an example where you have a group of people that say in one country that they've kind of view women as second-class citizens. Okay, but now you have some female managers over there. So in essence, they don't listen to them because they're females, and subsequently they don't follow policy. See, that's a cultural thing, and you got to figure out how to deal with that. Impacts perception of who is responsible for safety in the workplace. So when it impacts who's responsible, when you do investigations, one of the things they want to find out, where did things go wrong? Basically, who messed up? Or did everybody do everything right and this was just lightning happened to strike and there's nothing that could be done? So you want to make sure that you hold the people responsible, but when it comes to that, but hold somebody responsible for the things that's under their domain, not outside of. Affects the idea of what actions are appropriate for an employee to take when a situation appears unsafe. So realistically, this affects how people view things, what they should do, how they react to stuff when they see things that are unsafe. If you've actually got the right message out and the right training and the right culture, they're going to report that stuff immediately. If you've got the wrong stuff going, they might say, you know what, I'm going to act like I didn't see that, and I'm just going to keep going and let it be somebody else's problem. Training and supervision must apply cultural knowledge. So if you're going to have international safety implemented, promoting safety international in your organizations, you know, and if you take someone from the U.S. and you take them down to Brazil to do this training, they must understand the culture and how to give an effective message and reinforce it. Laws, enforcement practices, and political climates vary from country to country. So this is where it makes it really difficult for large organizations, and this is why they really pay some people a lot of money to stay abreast of these things so that they don't get in trouble. Listen, it's one thing if you're operating in 5 countries, but it's a problem, and which is good if you're in 5 countries and it's going good. It's bad if you're in 5 countries and in 3 of them you're having safety issues and it's costing you money. You have to look into that. So everything has to be in sync regardless of where your operations are. That concludes this chapter.